solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may be seated.
Thank you, ma'am.
Good afternoon, Mr. Kliem.
Good afternoon.
Could you please state your name and spell it for the record?
Sure, it's Lewis Von Kliem, and last name is Kliem.
Thank you. Where are you current?
Sorry, can you spell Lewis too?
Sure, Lewis. Yeah, and Von is VON.
Thanks.
Yeah.
Could you please state where you're currently employed and in what capacity?
Sure, I'm the Director of Consulting and Communications at Force Science.
Can you explain what Force Science is?
Sure, Force Science is just a company. It's not an individual type of science. But at Force Science, we have 4 divisions. We have a training division where we go around the country and we train police officers and community members. We train attorneys in how human performance issues impact use of force decision-making. We do that for civilians and police use of force decision-making. So that's our training division. And we have a consulting division, which I run. In our consulting division, we train attorneys, investigators, police officers, politicians, community members on how to evaluate use of force cases. And particularly our unique offer is we make sure that the evaluation includes what we call the human behind the badge. And so we're always looking at the big words of the psychological and physiological and environmental influences on decision-making and performance. So our job in consulting is what we refer to as this concept of honest accountability. And so what we do in that sense, what we train and what we consult on is to ensure 2 main things, is that the guidelines and standards and policies that we use to hold officers accountable are clear enough that an officer or even a civilian can predict the lawfulness of their own behavior. And so we go into the policies and the laws and we look at the language so they can do that. And then the second half is we have to make sure that the expectations on police officers or civilians are not beyond human performance capabilities. So we can't hold an officer honestly accountable to a use of force decision if we're expecting something that no human could do. So in our consulting division, we really focus on those issues. We'll talk a little bit about my background, a little bit about how we do a little bit more than that. But I'll just also say we have a research division led by Dr. Bill Lewinsky. I'm not part of the research division. But what the research division does is it pulls from multiple disciplines. So we have thousands of peer-reviewed studies that undergird our training. So our research division is constantly looking across like the National Highway Traffic Safety, sports, medicine, psychology, and we're trying to find, are there any human performance issues across all these disciplines that might apply to a civilian or a police officer involved in a critical incident? If there is, we then take those studies, those findings, because nobody really reads peer-reviewed journals, and so we translate them. We'll put them into articles, we'll put those out in police magazines, we'll put them out in psychology magazines, we'll put them out to where audience who will use the information can read it. So you won't find us in like a popular mechanics magazine, but you might find us, I think you've heard like Police One or Lexipol or some of these bigger law enforcement publications. If there's no research in a specific area, our research division what we do is we find those gaps and we'll conduct the research ourselves. So Force Science has about, not very many, maybe 30 peer-reviewed research projects that we've conducted through our organization. And again, I've only conducted one of them or been a part of one of them. The rest were done before I came or by other experts. Those are then published in peer-reviewed journals, and then we translate those as well into the audience. The 4th one is just training development. We train instructors and we do curriculum development. So those are our 4 areas at Force Science.
Have you ever analyzed use of force cases?
Yes, that's what I do for a living.
And in what context do you do that?
So our cases, we don't care who calls us. We work for defense, we work for prosecutors, we work civilian, we work police cases. We will analyze for internal affairs, we'll analyze for politicians, we'll analyze for media, community members. We don't care who calls us because our analysis won't change. It's just hoping to educate them on the human performance issues, the laws, the policies that regulate police conduct and civilian conduct.
How long have you worked in the criminal justice profession?
A little over 30 years now.
And what were some of your roles in the law enforcement?
In law enforcement, yeah.
Yes.
So as you could tell, I started out as a police officer. I started back in maybe 1990 as what I would call a baby cop. I was basically a reserve police officer while I was going to college. I'll just generically just say I was a reserve, and then I became a full-time police officer basically from, I think we're going to go through this. I'll just say I was a police officer, and then I became a lawyer, was a military attorney, and then a senior policy attorney. And I think we'll go through some of the details of each of those.
Yes, so break that down. You have a lot of experience, so we'll get there. Could you please summarize your educational background?
Yeah, so I have I'll start with my associate's degree. I'm just as proud as that, associate of science degree. But I have a bachelor's in crime and delinquency studies. I have a master's in criminal justice administration. I have a doctorate in law, so I'm a lawyer, so I have a law degree. And then I have what's called a postdoctorate, a master's in law degree, which is just the next level law degree.
Okay. And since you're licensed to practice law, are you licensed in any jurisdictions?
Yes, Virginia and Kansas.
And based on your CV, do you have any specialized education, training, and experience that qualify you to identify and assess the customs, principles, and standards that are frequently observed in law enforcement?
I do, yes.
And specifically that impact training, policy, evaluations of police practices, use of force, decision-making, and performance?
Yes, ma'am.
And you mentioned it a little bit, but you were a police officer from roughly 1993 to 2014?
Yes. And that was both full and part-time. So I did a lot of that part-time for about 9 or 10 years full-time. And then stayed on as a reserve officer. After I was a police officer, which I'll go through a little bit of what I did as a police officer, I was going to law school and working on my master's during the day while I was working narcotics at night. Finished my law degree, 9/11 happened, so I joined as an Army judge advocate. So I was a military attorney. And then I transitioned from full-time police work to just coming back weekends and holidays and working the street when I could through my military career. So I was a full-time attorney practicing law, and I would just come back and work the street when I could. There were some gaps in there, so I wasn't working that whole time, but there was a lot of experience during those times that I continued to have.
All right, so you're putting us to shame with 3 jobs at once, potentially?
Mm.
All right, so for the job that you attended a police academy for, were you trained in the use of force, foot pursuits, and traffic stops?
Right, so my first job as a police officer, you imagine we were trained in use of force decision-making, all the things you probably continue to hear. So traffic stops, investigative detentions, tactics, as you continue to hear a lot about tactics, and yes, of course, foot pursuits and traffic stops.
You were also a field training officer and in-service instructor, where you taught new and veteran officers police practices, use of force, traffic stops, de-escalation?
Yes, so my job, after you go on the job for a little bit, you transition to more of a supervisor, a training role. In that capacity, I was a trainer, I was a tactics trainer, I was a communications trainer. I don't think I mentioned this, but I was a crisis counselor before I was a police officer, so I also transitioned to become a de-escalation trainer, a communications trainer. I taught tactics. You heard force-on-force training, so I set up and conducted force-on-force training. I ran our defensive tactics program and our de-escalation and our use of force program. So we were seeing not just the brand new officers, but we were training outside agencies. We were training veteran officers and supervisors, and I led those divisions for a while.
You also listed some additional training that you received in your CV, and there's a few that I wanted to ask you about. Can you describe some of these specific courses that you attended? One of them is the FLETC, Police Legal Advisor.
Right, so this is more in my legal capacity. The Federal Law Enforcement Training Center had a police legal advisors course, so I attended that course and passed the test, was certified in that course. That just focused on really the federal constitutional standards for policing, which eventually I would spend a lot of time actually teaching and focusing on constitutional policing issues. The FLETC Police Legal Advisors course was the first certification course I went through to sort of prepare me to be a police legal advisor. So ultimately, you may hear that I did that for about 5 different chiefs of police where I was their legal advisor. That's the course that set that up, yeah.
Okay. And you also list NLETC, Basic, Intermediate, Advanced, and National Instructor. Can you tell us what that is?
Yeah, so that's one was the Federal Law Enforcement Training Center. That was purely academic. It was very heavy law-driven. The National Law Enforcement Training Center is all hands-on. So I was a basic instructor, intermediate, advanced, and ultimately a national instructor for the National Law Enforcement Training Center, doing weapon retention and disarmings, control and defense tactics, ground control techniques. Ultimately, I was a PR-24, which I don't even know if police still use those, but you've seen the side-handled baton with the kind of spinning thing. That I was an instructor for that, and also the straight baton. So these were all through the National Law Enforcement Training Center. That allowed me to train not just our own agency, but outside agencies from across the country. And as a national level instructor, I train the trainers. So my role now is less hands-on for the National Law Enforcement Training Center, and I'm really focusing on the legal aspects of use of force when I come in and teach for the NLETC.
And you also list the Force Science Advanced Specialist course?
Sure, the Force Science Advanced Specialist course is one we put on. I attended it before I worked for Force Science. It's an 18-week course where they bring in really some of the top experts in the country. They're outside adjuncts that come in and teach for Force Science, and some of these are the most prolific writers in a particular area. It's about 50 credit hours of college credit if you want to put in for it. I don't think I did. It's hundreds of hours of individual study, but the focus of that, and the reason I wanted to include that, is because that's where you really look and learn to apply human performance considerations in use of force encounters. So I want to make it very clear, that doesn't make me a scientist. There's no such thing as force science expert. Force Science is just a company, but what that course prepares you for, and there is no other course in the country like it, it allows you to issue spot human performance issues and the potential influence that they might have on decision-making and performance. If we then need to dig deeper, we would bring in somebody with a PhD or a medical degree or a psychology degree to tell you why those things are happening. This course prepares you to look for those things and to issue spot those things.
And it also looks like you have 50 college credits and hundreds of hours worth of independent training.
That was from I didn't actually put up those. That 50 college credits is describing the
Force Science.
the Advanced Force Science Specialist course. Yes, ma'am.
Okay. And it looks like you have quite a few in here. You've listed over 150 different training courses that you've taught or attended across the country in the last 5 years alone. So could you please explain the variety of audiences that you've trained in? I have a few courses that I have questions about, but if you could tell us who you trained.
I just wanted to highlight that my training particularly, is for attorneys, it's for civilians, it's for police. We train politicians, we train community members at universities, we train at FBI National Academy Association conferences, we train and consult with DOJ, we work for the defense. We've done training for defense attorneys, we've done training for prosecutors, I've done training for reporters. So really we're trying to ensure that any stakeholder who has an interest in understanding police violence or police decision-making is understanding the potential influence of human performance in those areas. And also a really big part of what we do with all of these stakeholders, which is really all of us in the community, is to ensure we understand the difference between a video presentation and a human's experience. So that's a big topic that we like to write about and train on.
And some of these that I want a little more detail on. So you mentioned evaluating use of force for executive leaders and attorneys.
Right. That was the last one I did. That was this year. That was in Riverside, California. So I do this personally across the country. That was a prosecution office and their investigators. And Riverside is massive. I think they have 180 investigators in their. I never heard of that. It's like a small police department. So their attorneys and their investigators attended this, and that one we specifically focused on how to evaluate use of force cases, where the human performance considerations and video analysis fit into a use of force case, and that was a prosecution office.
You also list human terrain mapping and behavior pattern recognition.
Yes, the reason for that is I just want to give a sampling of the audiences. These are tactical operators, so I still, although I'm not working the street, I still interact with, survey, train with tactical officers, and I also train them. That was a course that was specifically designed for tactical officers.
You also have U.S. Law Shield. What is
Right.
that?
The U.S. Law Shield is it's an insurance company is what it is, but that was a class where we taught the actual attorneys. I just wanted to ensure people understood that we train attorneys who represent civilians, not just police. So we actually will be part of teams representing criminal defendants, civilian criminal defendants. We don't just represent or work with police cases.
You also have Cumberland University listed.
Right. This is an example of a university. There were community members there and university students that we wanted to reach out to and give an opportunity to understand the reality of human performance in critical incidents. We also, with those organizations, will work with, you heard from Lon Bartel with Vertra. They'll bring their simulator in and we let the civilians run through those simulators so they can experience what it's like to try to make a decision as a police officer in those split seconds. And that's one of the most impactful ways we can sort of educate the community on the reality of a police officer's decision-making experience.
So it sounds like Force Science works with a lot of experts in the field of law enforcement, human factors, like we heard from Dr. Blake and Lon Bartel. Is that correct?
Yeah, so as a consultant director, you hear my expertise is police practices, use of force, threat assessments, responses, the potential influence of human performance issues in force encounters, and video. But I do this all as issue spotting. I connect the dots and say this is an issue that needs to be addressed. I'm also the one who says we probably need a psychologist here, we probably need a human factors PhD, we probably need a doctor. I won't do that part of the consulting or the testimony myself. So we have developed a network across the country of some of the top experts, and we try to work with them to fill in those gaps.
Are Professor Seth Stoughton or Nicholas Bloomfield part of that network?
They are not.
You also list the limitations of video for use of force investigations, use of force summit from December of 2024. Can you tell us about that?
Yeah, just if there was any question, that's one of the top rated use of force conferences. It's by selection only, and I just recently did a presentation there on the limitations of how video can and can't be used to judge a human's experience during an event.
You have many more, but I'm not going to have you go through all of them,
Yes, ma'am.
just for interest of time. In addition to this, has Force Science trained law enforcement officers on the use of force? Do you know how many they have? How many they've trained?
Yeah, I mean, at this point, it's probably hundreds of, I would say 100,000. I mean, there's tens of thousands, if not over 100,000 people we've trained through Force Science. I personally trained tens of thousands of officers at this point.
Has Force Science taught students or law enforcement officers in Michigan?
We have.
Do you know roughly how many?
I tried to look. I think it's roughly in Michigan proper over 400 last time I checked. I think just Grand Rapids and the Michigan State Police and Kent County, I think maybe 100 in total of that group that I could verify we've trained recently.
And you mentioned you've had several students from the Grand Rapids Police Department?
Yes.
In your current job, are you hired to conduct training and consultation in, I think you already mentioned this a little bit, but police practices, law, investigations, trainings, use of force, and evaluations?
Yeah, that's what I do full time now, yes.
And do you do this across country and internationally?
Yes, we recently had cases in Ireland. I'm going to Mexico City next month, I think. We've got a couple of cases I've handled out of Australia. So we're retained internationally and nationally.
Let's talk a little bit about how you ended up as an expert consultant in police practices, use of force, policy, and training. You have several experiences, and I kind of want to talk now about your law enforcement experience.
Yes, ma'am.
It looks like you taught defense tactics and use of force.
Yes.
And I know you mentioned some of this already. Patrol tactics, traffic stops, foot pursuits.
Yes, ma'am.
De-escalation, communication.
Yes, ma'am.
You've developed training, we're on a policy review committee, and have wrote use of force policies.
Yes, I did.
You were also on a high-risk warrant team.
Yes, so we had a difference between our SWAT team and our high-risk warrant team. So I spent much more time on the high-risk warrant team, which basically mostly was narcotics warrants. Ultimately, I ended up working for our SWAT team. I did that for a very short period of time. But yes, I worked both those.
And you also mentioned you're an attorney,
Yes, ma'am.
and you practiced law for about 15 years?
Yes, ma'am.
So I just want to go through some of your experience practicing as a lawyer as it applies to police practices, policy development, and use of force.
Yes, ma'am.
Looks like you taught constitutional policing, use of force decision-making, and investigations full-time to military and civilian police officers?
Yes, at the United States Army Military Police School, I was an Army judge advocate, so I was stationed there full-time for about 2.5 years, where I trained specifically on constitutional policing, which was use of force, Fourth Amendment, Fifth Amendment. So when you could stop somebody, when you could use force, criminal law, criminal procedure. That was both military and civilian police attended those courses, so it wasn't just uniquely military law. But I did that full-time as part of my military duties.
Thank you for your service. You were a police legal advisor for agencies including at least 4 chiefs of police and emergency services directors?
Yes, ma'am.
And that included the review of training and policies?
It did.
Did that include the review of use of force cases?
It did.
And you were also a prosecutor?
I was.
And you were a senior prosecutor for several years, supervising a legal team?
Yes, ma'am.
You were also a special assistant U.S. attorney?
Yes, ma'am.
Where was that?
That was in the Eastern District of Kansas. That was not, we had to evaluate, I personally evaluated those cases for mostly force necessarily. They were mostly attempted murder and sexual assault cases while I was in that capacity.
You were also the senior domestic operational law attorney for a multi-state region in the U.S.?
Right, so that's only important in that that's when I started to have to become very familiar with how different states and different jurisdictions handle police practices, because they all do it very differently. And so we had to integrate military with civilian operations for anything that happened in the U.S. And so I had to be familiar with very specific local laws and the federal laws, and then how to integrate those. So I was the senior legal advisor for what was the defense DCO, Defense Civil Officers, I think was what it was called. Defense Support to Civil Operations is what we was. But I was a senior legal advisor, and so my job was to start to look at how various jurisdictions handled police practices and use of force to make sure we could integrate with them.
And at one point, you were also the senior domestic operational law attorney at the Pentagon?
Yes, ma'am. So my job there was, again, it seems odd, I'll only explain because it's military. It sounds like, well, that's military, it's not civilian. My job was specifically to understand civilian use of force laws across the country now, because all of our military assets might have to integrate with them, and we had to find out where there was any differences between how we might operate and how they might operate. And so I was in charge, I was the senior domestic operational law attorney. I advised the highest ranking JAG, it was a 3-star, General Darpino, on domestic operational law issues, and it just happened to include a time frame where we had just had a potential terrorist attack in the U.S., and so we were writing policy very quickly. So I actually wrote Army and DoD use of force policy for that at that period of time.
And so you were also the operational attorney for the Army Criminal Investigations Command?
Yeah, what's important about an operational attorney versus, say, a litigator or a consulting attorney? An operational attorney works directly with the criminal investigators. So again, these are the ones where a criminal investigator might be at the scene right then. A police officer might have pulled the car over right away. And so you had to have a very high level understanding of police practices and use of force and constitutional issues, because they needed to have an answer right now. There's no time to study, there's no time to research. An operational attorney is the one who's advising those operational criminal investigators and police officers in real time. And so I had that job working for the Criminal Investigations Division for the U.S. Army. Simultaneously, I was working as for the Terrorism Criminal Investigations Unit, also as an operational attorney, where we just investigated terrorism cases.
In addition to your police and legal work, you worked for Lexipol as a senior policy attorney?
Yes, ma'am.
Can you explain the role of senior policy attorney in the development of model police policies?
Yeah, so after I retired from the military, one of my first jobs was for a company called Lexipol. When we started to hear some of these things about model policies and some of these organizations like IACP or PERF, the Police Executive Research Forum, Lexipol is among them. They generate model policies, they generate consideration papers. So my job as a senior policy attorney was to draft, literally write these model policies, and to customize or work with clients to customize those policies for local application. And so what is important about that is in my role as a senior policy attorney, I was required to understand the laws, the federal laws, the state laws, the local laws, the community interests, any political or cultural issues that were going on. I had to understand technology that was advancing through law enforcement. I understand reform issues as they were coming up, because we were having to look at what the current state of the law was and compare that to any recommended changes or reform efforts or any recommendations or reform efforts. And then our job was to advise on whether those types of changes would make it into the policy or not, make it into the model policy. So I think we'll talk more about what a model policy is and what it is not, what it's intended for and what it's not intended for a little bit later. But that job for about 2.5 years required me to have a very deep understanding across the entire country of police practices, use of force, and our cultural and technological influences on those issues.
Have you evaluated the adequacy of policies in the context of specific incidents or litigation as well?
Yes, ma'am.
Can you tell us a little bit about that?
Yeah, so when we take on a case, we're involved in a lot of the high-profile cases in the country, and so when we get involved, some of the first things we have to do is kind of look at the policy that the officer was operating under. And so we will then look at that policy, and my job specifically is to look for internal and external inconsistencies, because you might have a foot pursuit policy and a car pursuit policy and an investigation policy that we call it wallpaper. So if you wrote one policy and then you wrote the other one, you didn't recognize the same changes, then the officers are kind of confused because they'll end up having two different standards affecting the exact same conduct. So our job when we look at those cases is to look for internal and external inconsistencies within policy. Once we've done that, we look for inconsistencies between the policy and the local training, like the county training, or we'll look at state laws, and then we'll look at federal laws. So what we're basically trying to say is if we're going to hold this officer accountable to his conduct, we want to make sure that he understands clearly what the expectation was. So when we start to see all these inconsistencies between what's expected of the officer, we have to identify that for our client and say, look, you're going to have real trouble holding him accountable to a standard when he's being asked to follow 3 different standards, for example. And so we look for that. That's the biggest part of our policy reviews when we're trying to engage in what we call honest accountability of officers involved in these critical incidents.
Can you explain how your work incorporates human factors into understanding police use of force?
Right, so we've heard a lot about human factors. We've heard about action-reaction or action-beats reaction, auditory exclusion and auditory blunting. Human performance issues in our job in evaluating cases is really the entire point of evaluating the case, right? Because we are evaluating what an individual officer perceived. And so in order to do that, we're having to look at the bucket of information that the officer perceived and then what meaning they assigned to it. And whether that meaning, basically what cops know, what does that mean to a cop, is what drives their decision, right? When we try to figure out that initial bucket of information that we want to hold the officer accountable to, you have to understand that a human is involved in a critical incident. And so when you're looking at that human, you got to say, what are the psychological, physiological, and environmental influences on their ability to see something, or like we've heard in this case a lot, their ability to hear something. What is their focus of attention, and how is that going to impact their ability to see various different objects in the environment, right? So the human performance side, if we don't consider those in every aspect of a criminal investigation or of a use of force investigation, we've essentially taken the human out of the equation. And then we're just looking, which is obviously what we refer to as unjust or corrupt accountability, right? You can't hold an officer accountable to things that are beyond human performance capabilities. And I don't think anybody disagrees with that.
And you mentioned a little bit about action versus reaction. Can you explain how that's incorporated into these?
Yeah, so when you heard from other experts on this idea of action and reaction, there are certain human performance issues that almost all reasonably well-trained case evaluators or investigators are going to recognize. So these are not things you need a scientific degree to understand or see. We all see them, we all experience them. Police specifically will see them in training quite frequently. So we'll see auditory exclusion, we'll see tunnel vision, we'll have that described to us. And then we, in fact, will actually have to, they're so well known in the industry, we actually have to create tactics to mitigate them. So if I give you an example of that, auditory exclusion, for example, is so well known that if I have an officer involved in a fight with somebody, and we have these new policies, or you might have heard of called duty to intervene, right? So we want other officers to come in, look at the scene and go, hey, I think the guy's unconscious, I think the guy, we have him in control now, we can slow down the use of force. Two things are known to us as trainers. The person involved in the fight might not be seeing it the same way because they're focused on the fight. When you come in after the fact as an additional officer or as a supervisor, you're going to be like the referee of an MMA fight. You're going to see things. If you guys have watched MMA, sometimes the guy's knocked unconscious and the referee has to kind of push the fighter off, right? Because the fighter's not seeing it yet. Well, in policing, it's the same thing. We recognize and we have to mitigate. We have to have tactics that reflect the fact that this person in the fight might not be hearing us. And so we'll actually tap on them. We'll yell their name, we got him, let's slow down, I'm with you. And you have to become a more important stimulus than what they're dealing with. So we know that from a human factor standpoint, auditory exclusion means if I just come in and say, hey, Bob, I can't reasonably expect them to hear me because I know they're so focused, so we develop tactics. So those kind of human performance issues are well known and are part of policy development, training development, operations development, investigations, and then case evaluations. So you're gonna see it throughout, and you'll see within the police industry that police practices experts are often the most qualified people to recognize the influence of human performance in a critical incident, even more than the researchers who are typically doing clinical lab studies. We take what they have, and then we're the ones that actually do the application piece.
And you mentioned in a critical incident event. Can you explain why that is?
Why that is?
Yeah.
Yeah, you heard a little bit about rational decision-making and heuristic decision-making. I don't like that term. Sometimes judges don't let me say that term, heuristic. But what it just means is rule of thumb. What heuristics is, we all experience it, is there's certain patterns we see throughout life, and we basically go through like.
You haven't A, qualified as an expert, B, now he's talking about heuristics when he testified earlier that he can't talk about psychological things, that's why we brought in another doctor for it. So I think you're going beyond whatever you testified to.
I'm still going through his qualification. I mean, he has I'm trying to cut it. I've tried to cut out the most important parts, but he has a lot of qualifications that I would like to put on the record.
Talking about his qualifications is okay. Delving into definitions of things, I believe, would be inappropriate at this stage, as he has not been admitted as an expert in anything yet.
Okay. I may have a few more questions for you. I'll try to keep it quick. You also list that you've published approximately 75 published articles,
Yes, ma'am.
and your work is widely distributed across national police publications.
Yes, ma'am.
You've been published in dozens of publications, including Police One, For Science News, Michigan Chiefs of Police magazine. You mentioned Lexipol, International Law Enforcement Educators and Trainers magazine.
Yes.
And you're frequently interviewed and cited as a use of force expert in books, magazines, articles, news reports, and
Yes, ma'am.
professional magazines.
Yes, ma'am.
You've been asked to present and write for the IACP Legal Officers Conference and
Yes,
to
ma'am.
publish in the IACP Police Chief magazine.
Yes, ma'am.
And what is IACP?
That's the International Association of Chiefs of Police. I think we heard that from some of the model policies or consideration papers that were being offered.
You've recently presented at the Axon Taser Conference.
Yes, last week or 2 weeks ago.
You've been asked to present legal considerations for the Taser Master Instructor course.
Yes, ma'am.
And you have several organizations on your CV. I'll just go through a few and kind of have you explain or tell us if you're still a part of that organization.
Yes, ma'am.
So you're listed as an expert advisor for the International Association of Directors of Law Enforcement Partner Advisory Committee.
Yes, the International Association of Directors of Law Enforcement Education Trainers, they're an organization that compiles all of the individual state training, police training organizations, and they're an association that sort of organizes the conversations with those groups, and I'm on their expert advisory panel.
And you also are, looks like a member of the board of directors for the Association of Force Investigators.
Yes.
And a national level instructor at the National Law Enforcement Training Center.
Yes, ma'am.
It looks like you're a member of the American Society of Evidence-Based Policing.
Yes, ma'am.
And an instructor at the International Law Enforcement Educators and Trainer Associations.
Right, so the ILETA, an International Law Enforcement Educator Trainers Association, is just what it sounds like. It's an association that brings together annually the law enforcement trainers from across the world. They hold a conference every year, and they also have a publication that they put out to basically train the trainers is what it is.
Have you been retained previously as an expert consultant in police practices or use of force?
Yes, ma'am.
And what types have you served as an expert? Civil, criminal?
Yeah,
internal?
so as I mentioned earlier, so it's civil, criminal, it's police, it's internal affairs, it's civilian cases. If it's a force encounter and there's a stakeholder who's interested in understanding that force encounter, we'll work with them.
Have you ever been qualified and testified as an expert in a court of law?
Yes, ma'am.
Have you ever been disqualified as a police practices, policy, or use of force expert on any cases which you have been retained?
No.
Are you being compensated for your time in this case?
Yes.
Is your compensation contingent on the outcome?
No.
When evaluating police conduct, what methodology do you use?
Yeah, that's, so the first thing we do, so we look at how do use of force case evaluation, experts evaluate a case. The methodology for us, first you collect the available information, right? So we're trying to find out what is the bucket of information that the officer had perceived or was aware of during the investigation. So in order for us to do that, we look at the videos, we look at written statements, we look at the forensic evidence, if there's autopsies. We look at as much information as we can relative to their training, their policies, and once we have that information, the next step is then we start to answer two basic questions. The methodology to answer two questions: was the threat assessment reasonable, and was the response reasonable, based on what the individual officer had perceived and the information that or the meaning that they assigned to it. And so when we're looking at that, we're evaluating that case against the law, the policy and the training of that individual officer, and then comparing the law, the policy, and the training of the individual officer against their performance and against their decision-making as we understand it from the objective evidence. We then will make those comparisons and evaluate how those things stacked up, and then we'll write a report that provide our opinions on that. The biggest part of our methodology is as we're trying to figure out what the officer observed. So we'll talk about this concept of observe, orient, decide, and act. So what did they observe? What meaning did they assign to it? Part of the methodology is then to apply human performance factors across each of those domains, observe, orient, decide, and act, to see how an ordinary human would operate under those same conditions. And then another big part is we look at video evidence, and part of the methodology is to distinguish very clearly that a video is not a proxy for an officer's experience. The video does not tell you what the officer perceived, what they paid attention to, and so part of our methodology is to really be careful not to equate a video with the officer's perception.
And one of the things I think that you've mentioned was the local training and policy records of the agency.
Yes.
Why is that important to consider?
The standard by which we're judging the officer's performance is the local policy and the law of that jurisdiction. So we'll look at the state law, we'll look at the local law, and then we'll look at their policies and their training, because those are the standards and expectations which we're going to judge their performance against relative to their threat assessment and response.
And your methodology conforms to the standards of generally accepted, or is generally accepted by professionals in your field?
It is.
And you've talked a little bit about human factors and officer decision-making under stress. as widely understood and incorporated by reasonably trained police practices and use of force experts. Part of your analysis here will include some of those factors, but your testimony will be limited to what you've talked about so far today, right?
Right, so when I talk about any human performance issue, I'll talk about it in the concept of what a police practices expert and use of force expert would generally understand about the incorporation of those factors. I'm not a scientific expert. Like I said, I think that I can't talk about the concepts. Well, I will likely talk about the concepts as any other police practices expert might. I think we heard from the other experts talking about some of those general concepts. The distinction between me as a police practices expert and a scientific expert is that I will tell you what we typically see in policing and what we expect during the investigations. But if you need to know why those things are occurring or if they specifically occurred in an individual, something that I or any of the police practitioners or witnesses can tell you. Oftentimes, only the individual officer can tell you whether they're experiencing something. Our job is essentially to say, relative to human performance, if one side says there was a sound and the officer must have heard it, and he's lying if he says he didn't, we would simply say there are other explanations that could also explain that phenomenon. We're not saying which one applied, that's up to you guys to believe, but we're gonna say if you're gonna hold out that the officer has to be lying, we're gonna say, well, there are other human performance issues that could also explain that phenomenon, and we're just gonna make sure that the trier of fact is aware of those as well.
And in some of your reviews of other cases, have there ever been instances where you found that's not the case?
What's not the case?
That they, based on the review, that there may not be other things that play into how the officer is conducting himself in a use of force incident.
Yeah, so if there's ever the impression that we only defend cops or that there's no cop we're not willing to defend, there are a lot of cases we review where there's no human performance issue or police practices issue that's going to explain an excessive use of force. So our analysis will not change, and there are plenty of cases we evaluate where a human performance issue is not going to help explain a bad police decision or an excessive use of force.
And have you reviewed Professor Stoughton and Mr. Bloomfield's report in this case?
I have.
And do you agree with their methodology?
I guess I'm gonna have to object, he hasn't qualified in anything, we've been here, I don't know what she's doing.
I'm just sustained, doesn't matter if he agrees or not at this point.
Okay, Your Honor, I would move for admission of Mr. Kliem as an expert in police practices, police tactics, policy, and the use of force.
No objection.
So can you repeat that? Please.
I would move for admission of Mr. Kliem as an expert in police practices, police tactics, policy, and use of force.
All right, and there being no objection, I will consider him an expert in those fields.
And Mr. Kliem, have you reviewed Professor Stoughton's report and Mr. Bloomfield's report in this case?
Yes, I have.
And do you agree with their methodology?
No, I do not.
Why not?
There are two main errors that are inconsistent with how reasonably well-trained experts would perform this type of an investigation. The two biggest ones that I noticed that I would disagree with is one, well, maybe three. They don't actually apply human performance issues to their analysis. They I think potentially led the jury to the impression that there are generally accepted police practices and standards that officers, whether they have ever heard of them or not, are supposed to be held up against. That is absolutely not true. Officers are not held up against standards that they've never been made aware of. And we'll talk about that, I think, at length of why that is. Another major issue with their methodology is this case or any use of force case to be evaluated through the lens of the officer who's involved. And so you might hear that we look at it from a reasonably well-trained police officer. It's under the totality of circumstances, was it reasonable for that officer to believe, based on the information they had in the circumstances they were in, based on their knowledge, that there was a reasonable belief of the threat of death or serious bodily injury? What we heard from Professor Stoughton and I think Mr. Bloomfield is that there was sort of this sort of, I call it an avatar. There's this magical, reasonable officer, reasonably well-trained officer, and they even said, what would a reasonably well-trained officer have perceived? Well, if you understand what they just did there, they're saying that it doesn't matter what this officer perceived, what would some magical imaginary officer have perceived, and that's what we're going to hold them against. That is beyond human performance capabilities. So those are three areas where their methodology was inconsistent with what is generally accepted as a methodology for evaluating these cases. And there's a fourth one where you don't use a video. It's very difficult to use a video and then determine from that what an officer was thinking or what they were paying attention to. That is an objective third party or an objective two-dimensional video. It has nothing to do with the psychological workings of the police officer. And yet we heard some evidence from them that they relied on the video to tell us whether an officer did or did not hear something, for example.
Have you, and you mentioned some of Professor Stoughton and Mr. Bloomfield's testimony. Have you also been watching this trial since Monday?
I have.
Why have you been here in the courtroom with us?
Objection, what's the relevance? Who cares?
I guess I can move on, but if the jury hasn't seen him, I just wanted to explain why. But we don't have to. We-
So I'll sustain, that's not relevant.
Okay. Well, if you need to drink water or anything, you can
Thank you.
feel free. All right, so have you reviewed the incident involving Officer Schurr and the use of deadly force against Mr. Lioya?
I have, yes.
And what have you reviewed in this case?
I have there's an extensive list. So I looked at the videos, I looked at the officer statements, I looked at the autopsies, I looked at the Michigan laws, I looked at, this case has been working its way through courts in various levels, so I've looked at the basically the appellate record, the record of the case to kind of figure out what the law is. I've looked at the local policies, I've listened to the testimony of the experts, including the trainers. I think I've got a much longer, extensive list attached to my report, but those are basically the things I relied on.
Based on your review of those and your expertise, is it your opinion that a reasonable officer in Officer Schurr's situation believed that deadly force was necessary at the time it was used?
Yes, after evaluating this case, I think it was not only reasonable for an officer to believe that he was facing, in his situation, was facing a threat of death or serious bodily injury, but after listening to that testimony, these officers are specifically trained to believe that, based on the testimony you heard from your Axon experts, your taser experts, and the taser warning labels. These officers are actually trained to believe that they were facing a threat of death or serious bodily injury when someone has taken their taser from them and is in a condition to use it against them.
And why is the fact that the suspect had taken control of Officer Schurr's taser significant?
Yeah, so you heard this concept of intent, capability, and opportunity. So when we evaluate that imminent threat, we do something very similar to what Professor Stoughton described. We break it down a little bit further. It might be a little bit more useful, but we look at intent, ability, means, and opportunity. And if the officer reasonably believes, like they don't have to prove it beyond a reasonable doubt, they obviously don't have time for that. But if an officer reasonably believes that the person has the apparent intent, the apparent ability, the apparent means, and the apparent opportunity to inflict death or serious bodily injury, then they are authorized to use a quality of force to immediately and decisively stop the threat. They can use force to stop the threat right now. So in this case, when you looked at physical ability, he's moving, he's wrestling, he's gripping. I don't think there's any serious contention that he had the physical ability to use that weapon. The means is where the taser come into place. When we're analyzing the means, that's the weapon itself. And so was it reasonable for an officer to believe that a suspect who has wrestled a taser away from them has the means to inflict death or serious bodily injury? And again, is it reasonable for them to believe that? We heard extensive testimony that not only was it reasonable for them to believe that the Axon expert actually believes that himself and testified to that, as did Professor Kroll. So that's the means itself. So the importance of it is, in an imminent threat analysis like Professor Stoughton talked about, we're looking at intent, ability, means, and opportunity. The taser itself was the means. So what we're left with is the opportunity and the intent. And we can talk a little bit about why I believe those things were present in this case. Again, why do I believe it would be reasonable for an officer to believe they were present in this case? We can talk about that, but right now I'll just stop with the means itself.
And you mentioned that the framework is similar to Professor Stoughton, but differs in some ways, or is it?
Yeah, across the country, there's some variations of that. It's actually not a legal requirement. It's kind of a useful after-the-fact tool to use. So we've seen intent, capability, opportunity. We've seen intent, opportunity, jeopardy. We use intent, ability, means, opportunity, just to flesh it out a little bit more.
And is it your opinion that in this case, Mr. Leoya had the apparent intent because he fought very hard to disarm the officer, he didn't throw it away, he disobeyed the officer's commands repeatedly, he was capable of using it and began turning towards the officer?
Jack, now we're leading because she's.
Okay, I'll ask you what I'll withdraw that. What is your opinion about the apparent intent of Mr. Leoya?
Right, so one, you heard that officers are trained to believe that somebody takes their weapon, it's reasonable to believe they intend to use it against you. What is particularly relevant in this case is that Mr. Leoya did not just take the weapon and throw it away. He took the weapon, transitioned hands, and held it in a position capable of being utilized with just a simple trigger press. An officer, is it reasonable for an officer to believe that someone who has struggled that hard to take your weapon has the intent to use it when they've taken the time to transition it to what is typically a dominant hand, and to hold it in a manner that's consistent with its use and also does not throw it away? So based on that and his earlier failure or his refusal to obey lawful commands, the aggressiveness with which he resisted the arrest, those things to me would fall, a similar situated officer in those conditions, not only would it be reasonable for them to believe that, as a trainer, we would actually train them to believe that, and I think that was consistent with the training we heard Officer Schurr received.
In your opinion, would it be reasonable for an officer to believe that Mr. Leoya, by displaying the apparent intent, ability, means, and opportunity, posed a threat that could cause a person in Officer Schurr's situation and position to fear death or serious bodily harm?
Yes, again, it's just a reasonable belief. He doesn't have to actually be correct, but in this case, I believe that he was, or an officer in his position would have been. We've talked about intent, ability, and means. The final thing, part of my opinion, was opportunity, and the question is, would it be reasonable for an officer in Officer Schurr's position to believe that Mr. Leoya could actually turn fast enough and use that weapon against him? That's the opportunity. Was he in close enough proximity? So reaching under his arm or touching his leg, all those things were available from that distance, appeared to be available. But what I focused on as a grappler and a wrestler and a jiu-jitsu guy was how fast can someone in a tabletop position, as you've heard it described, actually spin and become flat on their back such that they're actually facing the officer. And that happens in, I think one officer said a second and a half. It's actually much faster. That can happen in half a second or faster. So in my experience training grappling and training officers in that tabletop position, or myself, you can actually turn and spin and face that officer faster than they can do anything to stop it. We heard, I think, quite a bit of testimony on action versus reaction. That's what that's describing. Once that suspect decides to start to turn, it's going to be too late for the officer to then engage an amount of force, a quality of force to actually stop him from doing it. So officers are not trained, and nor did I think they were trained from this testimony, specific to this case, to wait until someone points a gun at them, points a taser at them, or begins the assault against them. Is it reasonable for them to believe that if they don't do something right now, that they are in an imminent threat of death or serious bodily injury? And based on those four components and my analysis of this case, I didn't see this as a close case. As tragic as it is, I think any reasonable officer in Officer Schurr's position could have believed that that was necessary.
How do police officers, or how are they usually trained to perceive a threat posed by someone in possession of a taser during a close quarters struggle?
Yeah, it's what I just mentioned, and we heard that testimony, I think, as well, that officers are trained when someone actively takes your taser, you are trained to believe they intend to use it against you. And these are just reasonable inferences. So I got to make this very clear. A threat assessment and a response are just educated guesses by the officer. They don't know what's about to happen. The meaning they assign to all of this totality of the circumstances is based on their training, education, experience, and reasonable inferences. which is why if they don't have training, education, or experience to talk about any model policy they've never heard of, we don't hold it against them. We evaluate them based on their training, their education, their experience, and the reasonable inferences they drew from it. And so based on that, when he was evaluating the ability to turn and use the weapon, I found it was consistent with his earlier testimony and his personal training.
And is it consistent with standard police training or generally accepted police practices to use deadly force when facing an imminent threat of a taser being used against you?
Yes.
Why? Is there anything in addition to what you've already said?
Well, I think so when we're looking at an individual officer's decision, the question is, is it lawful for them to use a quality of force to stop the threat immediately? And if it's a threat of death or serious bodily injury, what is the quality of force that will immediately stop it? Hitting him in the head with a flashlight, I can tell you from experience, does not immediately stop a threat. Pepper spray is not going to stop this threat. He had to choose a quality of force that would immediately and decisively stop the threat. The question is that reasonable? And I think you asked, is that something I consistently see across the country? I don't like generally accepted police practices as a standard or as an evaluated model, but if you're asking me, do I consistently see across the country? I have personally, as a police practice expert and trainer, talked to hundreds of officers and asked them specifically, how are you guys trained if someone takes your taser, and it almost to a person with very little exception, it's we escalate to deadly force, escalate to deadly force. If someone disarms you of a taser, you escalate to deadly force. Now, you will hear a lot of people say, well, it's under the totality of the circumstances, lots of things to consider. To me, in this setting, that's almost a cop-out. It's like, okay, well, what were the circumstances? Let's evaluate them, and then let's decide with those circumstances, was it reasonable? So to answer the question, was it reasonable for an officer to believe that deadly force would be necessary to immediately and decisively stop the threat? That is something I see consistently across the country.
And once an officer makes a decision to use deadly force, do they need to try lower levels of force?
No, and very clearly, the courts have said repeatedly, officers are not required to try lower levels of force and hope for the best, particularly at a deadly force encounter. The question is, are they facing a threat of death or serious bodily injury? Is it reasonable for them to believe that? And then what quality of force is necessary to immediately and decisively stop that threat?
And what are, I know you kind of said that you base a lot of this on people you've trained across the country. Is there anything else that you base this opinion on? Have you
Well-
relied on anything, or any of the testimony that you've heard in this case that would be consistent with that?
Well, I mean, if the question is, was it reasonable for an officer in Officer Schurr's position with his knowledge and training and understanding of his own policies? We heard, I also would rely on the trainers of the agency that trained him and the policies that he was being subjected to determine whether or not his belief was reasonable. And so I also considered that.
Now I want to move on to the reasonableness of the foot pursuit and arrest attempt. You heard Professor Stoughton and Mr. Bloomfield criticize Officer Schurr for initiating a foot pursuit. Based on your review of this case and the Grand Rapids policies, procedures, the culture, was the pursuit within the standard of law enforcement agencies across the country?
Yeah, there's again, I will tell you, there's not a concept of generally accepted police practices that you can hold an officer against. If you're asking what we see from my perspective, having looked at jurisdictions across the country, you're going to see policies that are silent on the issue. They tell the officers, they address the officer in training. They address the issue of single officer pursuit or double officer pursuit based on just be aware of the risks that are involved in that and then make a good decision or make a decision. But there are a lot of agencies that have solo officer foot pursuits and encourage them, actually award their officers for engaging in them. Because if you understand what's happening, when you have a policy that says we only want officers to run with 2 officers, or we don't want you to do a solo officer pursuit, all that policy is doing is saying in our jurisdiction we're trying to balance the risk against the officer with the risk to the community. And an agency that says we don't want solo officers to pursue a suspect are basically saying we're going to prioritize officer safety over community safety in this moment. We're going to let the guy go and let the community deal with the safety concerns because we're prioritizing officer safety. Other agencies are like, no, our officers are supposed to assume risk so that the community doesn't have to. So if someone takes off running, of course it's dangerous. And that's what we pay officers to do, is to confront dangerous criminals and to actually go and arrest people. And so in those jurisdictions, they might prioritize community safety and crime prevention over officer safety. So you're gonna see them across the country taking different approaches, and each approach is really based on how that individual agency and jurisdiction wants to prioritize at least those two competing interests.
And in your view, was the foot pursuit and physical arrest attempt reasonable and aligned with how a Grand Rapids police officer would approach law enforcement?
Yeah, based on the test, there's no prohibition on an officer doing that, and you see that all across the country. There's plenty of agencies that officers still chase bad guys.
And do officers receive training to balance the risks of foot pursuits against their duty to apprehend fleeing suspects?
Yes.
And what are some of the things that you see?
Yeah, so what is understood in law enforcement training and tactics is tactics are discretionary. There's not a single tactical solution, there's just tactical options. And when an officer is facing a tactical scenario, they have to make their decisions based on risk, benefits, and trade-offs. And they're the ones that do it in real time based on some things just like their confidence level. Are they tired that day? Are they injured that day? The officer gets to decide, because there are so many variables, and I know this is true in Grand Rapids. They consider there are so many variables, they're not going to write a policy on foot pursuits because they need the individual officers in that moment to make those decisions. And so when you look at the types of things that officers consider in that risk, benefits, and trade-offs, you do look at, well, how tired am I? How far is my nearest backup? How, am I going to chase? Am I actually going to catch the guy? Is he bigger, stronger, faster than me? What do I know about the area relative to crime? What time of day is it? There are so many variables that go into that quick decision that a lot of places don't have a specific policy. And here's what's really important. All of these considerations and the totality of the circumstances of every decision, right? You keep hearing that. Do I chase or not? Well, it depends on the totality of circumstances. Understand the totality of circumstances are things that we consider in a classroom setting and we talk about them, and then we go into a training room and we operationalize them, we implement them, we do it in training so that they become aware of them. Once you're out on the street, you're not doing a math problem where you're counting the number of people and looking at the time of day. You're looking at it very quickly and saying, I've seen this before, and you make a decision. That's the heuristic decision, a rule of thumb decision, right? So we don't ask, and the courts don't require this, for officers to engage in this sort of library scholar approach to the totality of circumstances in that moment. The totality of circumstances are things we incorporate in training and in lecture, and then we look at after the fact in the evaluation. But in the moment, we expect in a critical incident, this is also in Stowe's books, I don't think you would disagree with this, that officers are not expected to engage in slow, deliberate, rational decision-making during a critical incident. They're expected to engage in what we call fast and frugal, system one, fast, heuristic decision-making. Why that works for cops is because all those totality of circumstances are things that we put in training. And so you heard their trainer say, we try to develop realistic training so that when they're on the street, I think he said I don't think he said automatic, but it's conditioned, it's automatic. Because you do not have time to do that math problem in real time, in many cases. And I think you asked that question, we'll come back to it later, but there are times when you can do slow, deliberate, rational decision-making. I think one of the experts talked about that, and there are times where that's just unrealistic to expect of any human.
And is talking about some of these tactics, are officers trained to follow a single tactical response?
No, like I mentioned, it's risk benefits trade-offs. There's tactical options. There's not tactical solutions. Sometimes you're actually encouraged to engage in agile thinking and thinking outside the box. And you're looking at a novel situation, and you come up with some weird tactic, and you go, hey, that actually worked. Tactics are basically feedback loops. You try them, you get feedback. You might alter and try something different. But this is happening in real time, and it's happening very quickly. And it's really important to understand that tactics, almost after any event, we could always go back in hindsight and say, oh, I might have done that different, I might have done that better. Officers are not required to try the optimal solutions. They're required to use a reasonable solution. after the fact, it is widely understood in the tactics world, you can always improve it. And using this court as an example, the attorneys will go back after this and do an after-action review and say, I shouldn't have asked that question, or maybe I was a little bit too aggressive with that witness, and I probably should have handled that one a little different. Every single real-time decision-making event, which is what's happening here in real time, requires you to do risk-benefit and trade-offs very quickly. The difference is an officer involved in a critical incident, the consequences are much greater than maybe in a court.
And do officers sometimes have to assume personal risk to prevent exposing the public to danger?
Yes,
of
that's
others?
what we expect of police officers, and that's what they're hired, equipped, and trained to do, is to assume the risk on behalf of the community.
And when someone suggests just to let the suspect go, what are the implications of that approach?
That you are prioritizing officer safety over public safety. You are predicting that if you let the guy go, that there will be no harm, but the officer will certainly be safer. The problem with that, what cops know, as we say, what officers know based on their experience, is that suspects who are let go does not mean the next time you come across them, they're not going to be more violent or armed or barricaded. We have case after case across the country where suspects are let go and the next day officers are killed going to serve the warrant. So when you hear this creative approach, is the most generous way I could say it, that you just wave goodbye and let the guy go and you can get him another day. Keep in mind that they are only imagining that getting him another day is going to be safer. There's no guarantee of that. And we have officers recently in Syracuse, they let a guy go to get a warrant, served the next day, 3 officers were shot.
We have to object in terms of what, other instances, we don't know the facts, we don't know the circumstances, so I think that's irrelevant.
Your Honor, this is directly relevant. These are examples of things that police officers are trained to look for. As Mr. Becker pointed out to Officer Schurr, there was an example of a Seattle Police Department shooting within their
So,
training.
but within the context of the expert, he can only apply the facts in this particular case in forming an opinion. So I'm going to sustain the objection with respect to this witness, bringing up examples.
Based on your review of Grand Rapids policies and training, I believe in your, did you create a report in this
I
case?
did, yes, ma'am.
And I believe you handed this out in your report. Does Grand Rapids have a policy that emphasizes confronting an individual or confronting someone who's running away, or rather than avoiding it?
Well, they do. And if I have a copy of my report. If I can read what it is in their policy specifically, if I can refer to my report.
Does he have permission to refer to his report? I think it's on, and actually, I think I have it here. It's Defense Exhibit E2. Or, sorry, it's the Manual of Conduct. It's E7, I think, Bob?
But he said he needed to refer to his report, which he has in front of him,
Oh, okay,
to help him answer the question, I believe.
okay.
Yes, ma'am.
Yeah,
So-
sorry.
So the answer to the question is yes. In Grand Rapids written directives, as I detail here, the Manual of Conduct, paragraph 12.1 B through F, employees shall professionally and completely perform their assigned duties and responsibilities of their positions. Employees shall perform their duties in a manner that is compliant with the highest standards of efficiency and the goals of the department. Unsatisfactory performance may be demonstrated by unwillingness or inability to perform assigned tasks, failure to conform to work standards established for your rank, grade, or position, failure to take appropriate action on the occasion of a criminal act, disorder, or other condition requiring or deserving of a police response, the neglect of your duty, or the display of cowardice.
And what did you interpret that to mean in the context of this analysis? Or how did that apply
Well,
here?
when Grand Rapids police officers are making decisions on whether they pursue or not pursue a criminal, or whether a criminal has decided they want to be arrested or not to be arrested, that they have this guidance that they are actually being encouraged to take appropriate action on occasion of a criminal act. They're being encouraged to actually enforce the law and to not shirk from their responsibility to act just because it's dangerous to them.
And is this consistent with standard police practices in Grand Rapids or anywhere in the country?
Yeah, so whenever I do a report or review of a case like this, is one of the first things I look for, because it's very consistent now, particularly, it's very consistent now in these types of cases where we're seeing things like, just let the guy go, just let the guy go, from some experts. And so we're constantly having to go to the policy of the agency and say, that is absolutely inconsistent with the expectations of the agency itself who trained this officer.
And I know there's been this generally accepted police practices term that's been thrown around. And I guess we'll talk about that in a little bit. But is it consistent that a police officer's tactics, if a police officer's tactics are imperfect, that they lose the right to self-defense?
No, nowhere in the country are officers been trained that if their tactics are suboptimal or imperfect or don't comply with some concept of generally accepted police practice, that they lose the right to defend themselves or that they lose their law enforcement authority.
And in your opinion, does choosing not to engage in a threat shift the risk from the officer to the public and to other officers who may have to confront the suspect in the future?
Right, so that's what I mentioned earlier, that when you stop, when you pull back for officer safety, for safety yourself, you're basically deferring the danger to the next person who has to confront this person and actually arrest them.
And in this case, was Officer Schurr's decision to pursue the suspect a reflection of that duty to assume the risk as someone, as a police officer?
Yeah, I don't know what he was thinking, but what I saw was consistent with an officer who was assuming personal risk rather than letting the guy go.
And throughout this trial, did you hear Professor Stoughton, and possibly Mr. Bloomfield, say that Officer Schurr's decision to deploy his taser at a close range was inconsistent with law enforcement training?
Yes, I did.
Do you agree with that?
No, and I think we heard plenty of testimony at this point that it's a close-range cartridge. It's designed to be used in close quarters. There's no prohibition on using it there. If it's used and it doesn't work immediately, there's a third point of contact. I have not ever heard that it's not. I think part of the argument was that he stood too close and allowed him to take it. And again, that's shifting consequences of the suspect's behavior to the officer. An officer can stand where he needs to stand. It would be tantamount to saying if an officer gets punched in the face, he shouldn't have been standing so close and therefore he's responsible. That's the logic behind that. Deployment in close quarters was unreasonable because it allowed him to deflect and allowed him to take his gun. It's just a use of force. That's what it looks like. They're imperfect and they're ugly, and after the fact, you might wish you stepped back or you might have wished you stepped closer, but there was nothing that made that unreasonable, even according to the TASER guidelines.
And the suggestion from some of the opposing experts suggests that the officer should have disengaged at that point. Are officers trained to disengage when a suspect is attempting to disarm them?
No, and what I noticed about that is as long as Officer Schurr was fighting for that taser, then he was not facing a risk of death or serious bodily injury so long as he maintained possession of that taser. He was fighting to avoid, I'll say he was fighting, I don't know why he was doing it. What I saw in the video and what I heard in his testimony was consistent with an officer who is fighting to maintain possession of that taser precisely so he doesn't have to escalate to deadly force. He's fighting to not have to shoot this guy because, as we heard, once he gains sole possession of that firearm, we go back to intent, ability, means, and opportunity. Right now, if you can infer intent, ability, and opportunity, the only thing he didn't have was the means. And Officer Schurr fighting to prevent him from accessing that means meant he didn't have to shoot him.
And based on your review, was Officer Schurr's attempt to retain his taser and get it back consistent with a reasonable officer's effort to avoid having to resort to deadly force?
Yes, it was.
Have you ever been tased?
I have.
Can you tell us about that? How did it feel?
The experience of being tased with probes was, for me, I challenged the guys. We all did this. You're going to tase. I've been tased multiple times, and I say, if I get to you, I get to hit you. Right? It gives you that mindset of I'm really going to try hard. And I couldn't move. I got tased. I couldn't move. You're just stuck. You can still see, but I was totally immobilized, and I had people catch me. That was not the worst experience. It hurt. It stopped me. I couldn't defend myself for sure. The worst one was I was grappling, not in a fight. Was grappling almost in a training scenario. When another officer drive-stunned me on top of the head to break up the grappling match, and I had that experience, and it was brutal. You heard from Dr. Kroll, it's the first time I heard that explained. Everything stopped. My eyes slammed shut. There was electricity that I saw. They told me it wasn't actual electricity, but everything stopped. I could not think of anything. My hands went straight up. The benefit was he just did it and stopped. He didn't hold it on there. But it felt like a stake was being driven into the top of my head, and there was nothing else important in the world other than to make that pain go away. And it made it worse, as Dr. Kroll pointed out, because I didn't know what it was, I wasn't expecting it, and it was a pain like I'd never experienced before.
And once you felt that pain, what happened? What happened? Were you able to do anything else at that moment?
During that pain, no. Until it was done, there was nothing else I cared to do other than make that thing go away.
Did it feel like someone pushing your head with their thumb?
No.
We talked a little bit about this term, but can you explain what the term generally accepted police practice in the profession?
Yeah, I can tell you what it's not. The generally accepted police practice are not a national standard. There were certain, if you're looking at things that we see consistently across the country, yes, there are certain things that are consistent, but that's not a standard by which we hold officers accountable to. They're generally accepted police practices are just things you might see consistently. When you heard about, for example, PERF and IACP and DOJ consent decrees and Lexipol, all of these organizations might have sort of model policies, sort of maybe procedural policies, and some of it's going to overlap. And all that stuff that overlaps, you can say, yeah, this is pretty consistent across the country. These are things you see frequently. What is critically important is that those organizations frequently do not agree on what those practices are. Some of those organizations, like the Police Executive Research Forum, their whole purpose is to elevate policing beyond the U.S. legal standard, beyond the constitutional standard. They want it to be harder for police, and that's their stated purpose. And so they're going to make certain recommendations that are consistent with that. IACP is probably the largest body of model policies, and they're trying to be able to write policies and considerations for the broadest range of police. And they're very attuned, because I'm on their legal officers section. IACP is very attuned to the cultural and political pressures that are on police, but they're also very dedicated to focusing on operational and tactical realities. And so if you look at history, you're going to find that what was being told to you are generally accepted practices. Those very organizations have had very strenuous debates about what is and isn't an acceptable or generally accepted police practice, or what the standard should be. DOJ civil rights, you heard this little idea about generally accepted practices will percolate up from the industry and that these organizations merely reflect that. That is not how that works. Those organizations some of them are activist organizations, some of them are political organizations, some of them are educational organizations and associations, professional associations, and they all have different priorities. What they're trying to do is, from the top down, influence the industry. DOJ consent decrees, for example, they're the opposite of generally accepted police practices. They're actually trying to get organizations to adopt certain standards under threat of litigation. These are standards that aren't generally accepted by police, but that the DOJ civil rights consent decrees can force them on organizations under threat of litigation. So if you're looking at generally accepted police practice, the only thing you really need to take away is they are not national standards, and they are not a standard by which you would judge an individual officer's performance who has never even heard of these standards.
And did you hear Professor Stoughton's definition of what he believes generally accepted police practices are?
I did.
without going into all the weeds of that debate, do you agree with them?
No.
Why not?
Again, what he was imagining is that all of these various international organizations and associations somehow has some consistency among them that create a national standard. But each of those organizations have documents within the organizations that specifically say these are not intended to create a national standard. Local agencies are only to use these for consideration in developing their own policies.
And I think you heard or you saw the testimony of Captain Siver
I did.
earlier in the week. And Mr. Becker had questioned him about the IACP considerations on foot pursuits. Do you remember
Yes.
that?
Yes.
And I believe, is this the document you showed?
This will show the whole policy. That's it.
Okay, so this is the foot pursuits July 2019 IACP considerations packet. On this, it talks about the considerations, concepts, and issues and need to know. Do you know what these terms mean from the IACP?
Well, they have definition sections, and I'm happy to read them, but generally speaking, a model policy is a starting point. It's a framework that people can look at. Essentially, the way I look at a model policy is that you can go home and cook yourself a meal, and you can do it from scratch, or you can go to a buffet who's already cooked the meals, and you get to pick from the buffet which ones you want. So a model policy is sort of that. It's what we did at Lexipol. We create a starting point for you. It's supposed to be more efficient. Ideally, it reflects various, the federal law, your local laws. But when we do a model policy, by the way, model policies do not ever automatically transition into a local policy. There's a process for that. But it's like just an off-the-shelf convenience. That's a model policy. What that is a considerations paper. It is by definition not a policy. It's just interesting things that smart people have thought about, and they're like, hey, as you guys are developing your policies, here's things we think you should think about as well. Here's things we think you should consider.
And just looking at this document, it says under considerations offered as an alternative to the bright line directives found in a model policy, instead of providing exact policy language, the considerations document outlines items that agencies should address and provides options that agencies should examine when developing their own policies on the topic. Is that your understanding of
That's
what
right.
that means?
Yes.
And how do you train officers or agencies to create their policies? How do agencies look at these types of consideration papers when creating their own local policy?
Well, I can tell you what's a consistent across either CALIA, which we heard a little bit about, or IACP, or DMS5, or Lexipol. I'll use Lexipol because it's one I'm most familiar with. When you take a model policy, Lexipol is not going to defend the policy in court. What we do is we call air gapping it, because we understand, we write the model policy. Ultimately, the local jurisdiction is the one who has to own those decisions. And so they're going to take our model policy, and what we would encourage them to do is work with their senior law enforcement officials, their prosecutor's office, their legal advisors. We're going to ask them to talk to their politicians. We're going to ask them to talk to their officers. All of those stakeholders are going to become part of what in this model policy do we think reflects our culture and our capabilities and our resources, and what do we just absolutely reject? We don't like that at all. And there's plenty of examples within each policy of things that they can choose from. So some people don't like the carotid neck restraint. They just think it looks bad, and so they don't want to have it in their policy. They'll say, we'll keep that at deadly force. Other ones like, nope, it's incredibly safe. We're going to put it down there with pepper spray. Fine, those are their choices to make. So when we look at this idea of the stakeholders meeting to decide what in the model policy do we like, what are we going to incorporate, we expect it to involve their legal advisors, we expect it to involve their police officers. Once they've done that, we also would like it to include their community members. And so you'll have community listening groups, or you're going to present these policies. I recently did this in Bakersfield, California. So you'll have the ACLU there, you'll have community members, you have your local police, and then you'll have someone like me to come in and talk about what are generally understood concepts and concerns about use of force investigations or use of force in practice. And then in those listening groups, the community then gets to say, we like that or we don't like that. That's where you might see a community says, we don't want you chasing bad guys. We don't want you chasing them through our cities. Other ones are like, we absolutely want you chasing them through our cities. And that's where those policies are ultimately shaped. Once the local government, right, whether it's the chief of police or through their politicians, however they decide to approve it, they decide how they want to craft it based on their resources, their risk assessments, their insurance requirements is a big part of it. They will then adopt it, and we call it air gapping it, because once they adopt it and they own it and they sign it, Lexipol's no longer on the hook for the decisions they made, because they made those decisions based on their local considerations.
And in evaluating a Grand Rapids police officer's conduct, how would someone compare that to the national ideal? Would it be something that would be compared to these national standards or the department's policy and constitutional law?
Now, ultimately, when they're doing the crafting of it, when they're taking these model policies and they're bringing it down to their local, that's where those discussions are being had and those considerations. But once they made their decisions, the binding policy, the binding expectations on the officer is what they're trained against. And again, we have a concept called operationalizing policy. We can't hold an officer accountable to the performance on the street simply because a piece of paper has words on it. What has to happen, once that piece of paper with words on it is approved by the local jurisdiction, it then has to get incorporated into training. Then they have to train against that policy. Sometimes they have lectures, and then they put it in their training. And then when they get out on the street, it's become operationalized, so long it was good training. Then they know how to incorporate that policy. National standards or these national policies that haven't been incorporated, haven't even been approved by the local jurisdiction, certainly have not been operationalized. The officers may not even know about it. And this is something I have to remember, is I deal with this every day across the country looking at all these. A local police officer has a hard enough time just knowing their own policy and trying to conform with their own policy. I've not seen where local police departments with their own policies have suddenly decided to hold an officer accountable to a policy they've never even heard about, and certainly doesn't apply in their jurisdiction.
So when a department like Grand Rapids adopts a use of force policy reflecting its specific legal, political, and operational realities, I think you said, is that in line with, I guess, generally accepted police practices or standards across the country?
Yeah, so we like best practices or generally accepted police practices when it comes to processes and procedures. We don't like them with tactics. Like, tactics is too much variety. But if you're asking me, is it generally accepted as a policy development practice? It absolutely is, yes.
And just to reiterate, based on your understanding of the Grand Rapids Police Department policy, Michigan law, and the circumstances, is it your professional opinion that a person similarly situated with the knowledge of Officer Schurr could have reasonably believed that he was in fear of serious bodily injury or death after he was disarmed of his taser after fighting for over 2.5 minutes until he could not fight any longer?
Yes.
Thank you.
You want to take another break here, Honor? You said we were going to take 2:10, and it's already 10 to 4, so I didn't.
Take a break or take a little later.
Less than an hour, so this.
Yeah, I guess we'll take another 10-minute break like I promised. So we'll come back at 4. So meanwhile, please remember to leave your notes upside down in your chairs and not discuss the case with each other or with anyone else. Also, continue avoiding any news reports about this case in the media or on social media, and then we'll see you back at 4. Welcome back. You may be seated. Back when you may proceed with your cross-examination.
Thank you, Honor. To make sure, your testimony, For Science is a business. It's not, it's got science in the name, but it's a business.
Yes, sir.
And business is trying to make money as a business. It's not a nonprofit, right?
It is not a nonprofit.
one of the things, being a business, it caters to law enforcement. I think I've seen you say that one of your largest influences in the law enforcement industry, right?
Absolutely.
Because that's who your constituents are. That's who you market to.
The answer is, since I came on, that was actually something that was a problem when I first came on in 2018. The perception was we only really were marketing to police. One of my jobs as the Director of Consulting Communications was to expand that. And as a Director of Consulting, I've gone to great lengths to expand it beyond law enforcement to civilian, where a lot of our cases now are civilian cases and a lot of our audience are not police. But you're absolutely correct. Historically, before I came into the company, they had a reputation for really focusing on police training. And it's still a large part of what we do. We haven't expanded as much as we'd like yet, but you're absolutely right. It is still a large part of our audience.
Now, part of that being part of your audience, you yourself has described yourself as a cop with a law degree, right?
Yes.
And you're very proud of that. You wanted to be a cop.
I love being a cop, yes.
Love being a cop. You said cops are one of the good guys, so that's why you want to be a cop.
Say that again?
Cops are the good guys, so you want to be a cop.
Well, I give them the presumption of regularity, and absolutely, yeah.
Sure. Well, that was one of my other questions, because you go on a number of websites. When you start, you give police officers a presumption of regularity, of the benefit of the doubt, if you will.
Yeah, so when we start, we give them, especially in a case like this, we give them the presumption of innocence. That's the first thing. And then we give them also a presumption of irregularity, and then we start to look for deviations from that.
But if you start with a presumption of regularity, that's not unbiased, right?
No, I'm not unbiased, and the reason for that is because when we as a community hire our police officers, train our police officers, they get background investigations, they're then trained and put into these conditions, that my starting point just as a community member is that I can give them the benefit of the doubt. Now, in my job, I certainly see a lot of bad examples of policing, and so they can lose that benefit of the doubt. It's theirs to lose. But yeah, just as a community member, I do give police the benefit of the doubt.
Okay. And you also have stated that Force Science has a reputation that there's not a cop out there that you would not defend, right?
Well,
those are your words.
Yeah, since I've been on, that's not our reputation anymore. We do a great job of trying to explain, even in court or at our conferences. My job specifically is to change that narrative since at least 2018, 2019. It's absolutely not true. There are plenty of cops. We don't defend cops, by the way. We just educate juries and evaluators. But there are a lot of police officers whose cases we review that we do not have anything to say that's going to be helpful to their case. And we make sure that the communities know that and that the jurors know that.
Now, part of the thing you put out, you have a website, Force Science website, that you have articles you put up.
Yes, sir.
And you went on that website, you got 3 of the top articles for 2024, your own articles. Do you get to vote on that, or your staff just trying to kiss up to you a little bit?
No, the article selection on top articles are based on the number of readers and how many people push them out. There's no people involved. It's really a statistical analysis of how broadly the reach was on it. So there's no voting on it. Okay. I would vote for my articles, though, in fairness.
Sure. But those articles were, the first one was Homicidal Empathy, an Evolving Threat to Police Officers. That was what you wrote.
Right.
Next one was Officer-Created Jeopardy, a legal theory that threatens effective policing.
Absolutely.
The Expert Trap, protecting police from unreasonable expectations.
Yes, I think that was the Michigan.
So those were all yours. Those were all your articles. Those were what you wrote about: protecting police, threats to police, threatening police. Correct?
Yeah, and those concepts
that's
against police officers.
I didn't need to. I just correct. Didn't ask you to explain.
You want to rephrase it? I want to answer them, but go ahead.
Yeah. Well, that wasn't my question. My question was those were the 3 things the 3 articles that were there are all about threatening police, protecting police, how to save police, essentially. Correct?
Essentially, no. So if I can elaborate that, yes,
well,
it incorporates
I
police.
Elaborate. This is not your chance to just talk.
Objection, Your Honor.
I ask a.
You should be able to finish answering his question in the same way that Professor Stoughton was allowed to answer every single one of Mr. Regula's questions as a long narrative. So at least let him finish his answer, please.
He's going beyond my question. I'm asking a simple yes or no question, and he wants to pontificate. So,
Essentially, no, is my answer.
Okay, so, I didn't rule on the objection, so, I mean, I believe this should be allowed to, complete his answer, but also not go into extensive elaboration. So, I guess we'll move on from there, and obviously you can ask him to finish whatever that thought was.
One of the other articles in 2024, maximizing the officer's recollections before the big interview. That was one of the articles that was on Force Science in 2024, correct? You need
Yes.
to look at it? I can show it to you if you want to look at it.
Yeah, I'm assuming you're pulling these from the website?
Correct.
Yeah. This is what year? 2024,
Last year,
yeah.
2024.
I don't think I wrote that one though, but
You
yes.
did not write this one. But part of this, the big interview is officer-involved shootings. That's what the big interview is talking about, correct?
I would consider that a big interview, yes.
Sure. One of the things they talk about in the article is perhaps the optimal solution is to conduct face-to-face interviews as part of the attorney-client preparation phase, where nothing is generated during the unclean recollection process will be discoverable under the attorney-client privilege. So you're advocating, your article's out there saying police officers should interview their attorneys, go through it once before they do an interview with the fact finder. That's a fair statement?
That's not my article, sir.
Well, but you're the chief communications officer. Buck stops with you, right?
I am the editor, but I do not write every article that goes in
Great.
there.
But aren't you responsible for what goes out on your website? You're saying you're not responsible for stuff like this?
I will not adopt every sentence that an author writes, particularly if I haven't read it. I may very well agree with the statement, but he's only provided me a small snippet, so I'm not going to tell you that I agree with everything. I don't even wrote that. Was it Geiselman or?
That was Greenman?
Greenman, yeah, so I can't adopt everything Greenman said. Oftentimes when we publish stuff, it's basically for the industry to consider, and they'll decide whether they agree with it or not. We're not endorsing everything we publish. We find it interesting for the audience, and the audience can read it and adopt it if they choose. Much of what goes out I do agree with, but without reading specifically every sentence, I don't know that I agree with everything Dr. Greenman said.
Well, this is another one on your website. It's from 2018, but it's still on your website. Veteran attorney cites 10 ways to lose police lawsuits.
Okay, this is before I worked there.
Before you worked there, but it's still on your website. I mean, you can't distance yourself from something you're the boss of, can you? And just say, I mean, you say you're trying to put good information out for police on your website, right?
Yes,
So, yeah, if you got bad information out there, you probably want to take it down, don't you?
no.
No.
You want me to explain that?
No, not really. So you talked about Lexipol. Lexipol is Bruce Pratt. Bruce Pratt, was that the CEO?
No.
Okay. He was not the former CEO and co-founder of Lexipol.
He was a co-founder of Lexipol, he's an attorney out in California,
Okay.
yes.
But did you know him? Because you said you worked for Lexipol, right?
I know Bruce Pratt, yes.
Okay. So you worked with him?
He did not work for the company, but when I worked there.
All right. And one of the articles in this article, he talks about how to save police from lawsuits and is how to clean up injured suspects before photography.
Yes.
Okay. Bloody pictures of suspects injured by police don't help your case in civil court.
Correct. He said that, yes.
He said that, but this is a publication on your website
What
that you're
webs-
sending out there.
For science?
Yes. It's, do you not see, is that the FS right there, for science?
Oh,
Take a
from
look at it.
Schremsburg, okay. That's Chuck who wrote that.
Okay. It's out there on your website. Focus closely on the actual injury. Get him to smile for the camera if you can. And don't include pictures of bloody gauze. That's on your website about how to handle people who are injured by police in incidents?
It apparently is.
Do you have a problem with that?
Thank you. In fact, that was the specific issue that Bruce Pratt and I talked about, and I would agree that that's absolutely inappropriate. It was one of the few conversations I had with Bruce Pratt. The reason these things are on our website is because if you look at Force Science News from the beginning of, I don't know, 2000, whenever it started, there's hundreds of articles there. And one of the things that we do like about it is almost an encyclopedia of looking where police was what has evolved over time, what has stood the test of time. There are a lot of articles back there that we would look at now and say, yeah, that's not how we do things today, but we maintain that library to show an evolution of policing, and it's very effective for that. So there are a lot of articles that we could sit here all day and I could go, yeah, that's not one I would agree with. I don't think it reflects modern policing. However, we leave those in there because it is an amazing library to look at the history of policing through that time frame.
So you're saying, 2018, veteran attorney cites 10 ways to lose police lawsuits. That was 2018. But in 2024, we have evolving threat to police that you wrote, legal theory that threatens effective policing, and protecting police. So where's the evolution there?
The evolution I'm talking about is a much broader from police practices and legal approaches and how the law changes over time, how technology changes over time. That's the evolution I'm talking about. You're looking at a small snippet of articles that I don't think I wrote and were probably before my time.
The 3 from 2024, you wrote those, you admitted those. The 3 the last ones I mentioned were your articles, you wrote those, you admitted that.
My articles are great, yes. I'd adopt those.
Okay. Part of, we've talked about it a little bit before, but Force Science is primarily law enforcement officers who are or former law enforcement officers or actual law enforcement officers that are actually employed as on staff, correct?
I don't know that that's, we have 1, 2, 3, 4, maybe 4 of 8 people, or actually more than that, say 1, 2, 3, 4, 5. The answer to that's no.
Okay, I went on the website, we can pull it up if we need to. You've
Well, you
got
did-
five staff instructors, correct?
Oh, you want staff instructors or
Staff
employees?
instructors, 5, okay, let's go staff instructors, the people who are instructing, 5 of you, right?
That sounds right.
Okay. Mr. Lewinsky, now he's
Never-
not law enforcement.
Never police.
Never police, but the other 4 are. You and there's other commander, the other 4 are former police, correct?
It's likely. We definitely are looking for highly educated former police officers to help educate the population we're interested in, yes.
And then you have 19 partnering instructors. 9 are retired police, and 1 is a lawyer, Laura Scary,
Scary.
and her work was defending police officers in civil and criminal suits. Is that a fair statement?
You'd have to ask her what her bulk of her work is.
You don't know? I mean, you work with her, don't you? I mean, she's listed on the website as a staff instructor.
Yeah, to understand, I don't work with any of these instructors. I mostly teach them, I say I don't work. Nicole Florese and I teach quite a bit. The rest of them are off teaching classes. I'm the director of the consulting division. The classes I teach by myself or maybe with Nicole. Every now and then I might partner with one of them, but I'm not part of our, what I call off-the-shelf training programs. So who's currently teaching, I'd have to look, and I might be surprised at who our new staff is as well. But if your point is, do we have a lot of former police officers, the answer is yes.
Now, even though Mr. Lewinsky is not a law enforcement officer, he was inducted to the National Law Enforcement Hall of Fame in 2023, wasn't he?
I think it was a lifetime trainer award, yes.
Okay. You just gave a presentation at the National Law Enforcement Hall of Fame induction ceremony, didn't you?
Yes,
That was just a few weeks ago.
it was.
And that was in partnership with Virtra. I heard from, is that how you say it? I can't say that. I've tried to say it.
Virtra?
Virtra.
Yeah.
Okay. That's Lon Bartels. That's his organization.
Lon Bartel,
Lon Bartel.
that's who he works for. He was not part of that training.
All right. But you've trained with him in the past, though, haven't you?
Lon?
Yeah.
Yeah, as often as I can,
As
yes.
often as you can. How many times have you trained with him in the past?
Taught classes together, maybe
Yeah.
3 or 4.
Okay. Done other presentations, though, with him? I heard about the SHOT show that you did with him?
That's one of them, yeah. What we try to do with Virtua is bring their simulator in. So we like get the community into the simulator so that they can experience what police officers are. That's what Virtua does. So we bring them in as often as we can because they've got amazing technology.
So I guess if I understand you correctly, one of the things is the consulting group, you're the head of the consulting group for Force Science, right?
Right.
So one of the things you do, I've seen it on just about every podcast, you kind of give your plug for your podcast. Hey, if you've been involved in an incident, fill out a form, send it into here, we'll talk with you, make sure your attorney's present, and we'll go over your case. That's kind of what you do,
Yeah,
correct?
that's our pre-consult process.
Pre-consult process, and you want to make sure their attorney's present so you don't get subpoenaed, right?
It has nothing to do with the subpoena. It has to do with there is no attorney-client privilege between me and the officer or the civilian who's involved in the incident. So their attorney needs to be present so that they can protect that relationship and the disclosure. Otherwise, essentially they're not able to tell us enough information that we can have an intelligent conversation. So as a protection for the people calling us, we want to make sure they know, hey, when you call us, make sure your attorney's with us. So that way it's a privileged conversation.
So you can't get subpoenaed to whatever they tell you,
Well, I could still get subpoenaed, yes.
but you can't tell them anything. You can't tell anything if there's an attorney there, there's attorney-client privilege. If they're not there, you're free to talk to anybody about what happened.
Right. Well, no, that's not true. We still have our own confidentiality. So we will, if there's no attorney-client privilege, we're still going to not disclose the contents. If we are subpoenaed and a judge tells us that we have to disclose it, of course we will. But we still have a professional confidentiality agreement that we're not going to tell people about those cases.
Now, in terms of that consulting, isn't it true that you've said 98% of the cases you see in force science are absolutely professionally well-done cases, officers not at fault?
Yeah, they fall within a reasonable range of options, yeah.
So 98% of the time, when somebody calls you, we want to consult with you, 98% of the time, the police officer is correct?
Overwhelmingly, police officers across the country are correct in their decision-making. I don't think you'll find statistics that disagree with that.
That's almost 100% success rate for any profession. That doesn't strike you as a little bit odd?
No.
Okay.
I mean, 98%, I don't have an exact percentage, but I'm
But
telling you.
those
on
were
the
your
cases
words.
we see, right?
But that, I'm just quoting your words. It was on one of your podcasts, remember, Law Enforcement Today, choir practice, some guys, you had a bunch of bourbon in the background, two guys. Those were your words. 98% of the cases we see are absolutely professionally well-done cases. Those are your words.
Yeah, that sounds about right.
What kind of put you on the map was a 2000 article in Police Marksman, why the subject is shot in the back. That was kind of one of your big articles that kind of put you on the map, didn't it?
Not me, no.
Well, okay, you're correct, but Mr. Lewinsky, your founder, that was one of his
Yeah,
big
Bill
research.
wrote that.
Okay, but that was one of that kind of got you on the map, didn't it?
I think the concepts behind it certainly did.
You're aware you're heavily criticized in a number of different courts for science, isn't it?
I'm not.
You're not, but Force Science is. They got a case from federal district court in Florida. Force Science is widely regarded as a purveyor of unreliable pseudoscientific analysis engineered to justify officers' use of force. Its studies virtually are all non-peer-reviewed, and none of them have been published in scientific journals.
Yeah, that's absolutely not true, and anybody who tried to present that to a court would be in violation of an ethical duty of candor to the court. I'm sure you've looked and seen that there's over 30 peer-reviewed studies on our website in some of the highest rated journals in the industries. So whoever advanced that position to the court was essentially lying to the court.
It was a court's opinion. You gotta take a look at it.
I don't need to, I've seen it.
He already said it wasn't him, so what's the relevance for this?
That's actually, I'm sorry, go, yes, ma'am.
No, that's fine. We'll move along. You talk about going to universities, Cumberland University, to train kids, train the kids at the universities, correct?
There were kids there. That one was actually open to community and politicians and law enforcement as well as the students.
But you've had, this is always a bad thing, and we're going to bring up Ohio State University in Michigan, but Ohio State canceled trainings because some of the classes where attendees could learn how threatening suspects can be shot in the back by a well-trained officer who made a valid, lawful shooting decision. So Ohio State canceled the presentation there, didn't they?
They did.
You've been criticizing the New York Times and other mainstream media, but you're okay with that because that means you're over the target, doesn't it?
The New York Times article was before I was there, it was 2015. It was basically an opinion piece. The author was given an affidavit to demonstrate that what he was putting in the opinion was incorrect. His response to us was it doesn't have to be correct, it's an opinion piece. There was a lot of fabrications in the opinion piece. We sort of let it go. And if you want, I had to actually research this because it was well before my time. The New York Times opinion piece was ultimately created by people who oppose us in court. So if we're effective in court in educating juries in a way that's inconsistent with their theory of liability, they're going to write opinion pieces that are unfavorable to us, yes.
And one of the things you do is you use this testimony to go out and then talk to other police officers. You testify in court and then you give presentations about what happened in court, don't you?
We do. That's a feedback loop, so we can get lessons learned and kind of understand what was important to the jurors or what sort of arguments the opposing sides were making, so we can sort of educate the industry.
So you did talk in Michigan, the Police Officers Association of Michigan, October 10th of 2024. You talked about officer facing 48 years, six others charged, and you talked about your experience in Colorado when you testified for a police officer, correct?
I don't know that, was that a presentation?
Well, that's what we got. It's a webinar, highly anticipated webinar.
Oh, this was at Caliber Press. That was not in Michigan.
Well, it's to the Police Officers Association of Michigan, nobody.
They were Caliber Press is one of the largest police training organizations. They wanted to do a webinar to discuss the facts of the case that they were interested in, and then found out we were involved with, and so they hosted a webinar. It looks like they were advertising that webinar.
But you talked at it.
I was on that.
You were on it. You were the star person. It's, Vaughn and Jim will dive. Jim Glennon. Vaughn and Jim will dive deep into the tactical and legal implications of the case. So you talked about. You went to the police on a webinar and spoke about it, right?
Yeah, this was a high-profile national case where Caliber Press itself didn't understand the facts of the case, so they brought in somebody who was familiar with the facts. I got permission from the defense team to discuss the case as part of educating the community on what actually occurred in that case, because the media and the facts that were being distributed looked nothing like the reality that the officers were experiencing. And so that was one of the mechanisms by which we could educate the community on the reality of that particular incident.
It's also one of the ways you can kind of promote for science, right?
Yeah, everything we do that has Force Science's name behind it is a promotion for sure.
Well, not only that, but when you go, just about every time I've watched your podcast, one of the plugs is after you say we're consulting, you advertise, hey, come get certified as a Force Science analysis, don't you?
I don't know that I do that enough, actually. My marketing guys tell me, hey, don't forget to tell people about our training classes. So oftentimes when I do a lot of public speaking, I try to remember to give those advertisements, those plugs for the training that's going on. We think we have a very good product that's important to the community and to the attorneys, and we want to make sure they're aware that those products exist so that they can take advantage of them.
And at $1,600 a person, that's one of the ways you pay your bills as a business, isn't it?
Yes, and that's incredibly low. It's a week-long class. It's a good investment for the individual officers for sure, but it's actually probably worth quite a bit more than that.
And in terms of that, how many of those trainings do you do a year then?
I don't know.
You don't know?
I don't know.
Going into those trainings, I did find an article about somebody was saying how wonderful your training was. It was on Force Science, but you had Laura Scarry, an expert in police litigation and management. Her expertise reflected insights that can only come from representing over 100 police officers in moments immediately following their critical incidents. Why do you need a labor attorney representing something that's Force Science that's supposed to be teaching about, psychological behavior, psychological factors, behavior, and memory?
Yeah, so Laura Scarry is an operational attorney as well. So when an officer is involved in a critical incident, she's the attorney who actually shows up to the scene. And so she's very familiar with the human performance issues in the immediate aftermath of shootings, and also the legal issues. So what she's trying to do when we're teaching investigators and those who evaluate cases, what they can expect. A lot of people have never done these before. What they can expect in the immediate aftermath of a shooting, particularly in relation to the officers that were involved. Laura Scarry is an incredible resource for that purpose.
You're not a big fan of progressive police reform, are you?
I mean, there's some aspects of progressive police reform that I think are fantastic, and there are some that I think are either beyond human performance capability, or they just reflect a very different priority than traditional law and order interests.
Okay. This is one of the articles you wrote on that, isn't it? 2021, progressive police reform.
Yes.
Okay. In this article that you wrote, you really don't like body cameras, do you?
I think body cameras are amazing tools.
You wrote, if you believe that police are racist, abusive, and corrupt, then it makes sense to mandate body cameras and enact policies that prevent pretext car stops, restrict consent searches, and limit investigatory stops. That doesn't sound like it's an amazing tool to me if you think the way you're mandating them is because their police are racist, abusive, and corrupt.
will you read that again? I don't know what
Sure.
you're talking about, the body cam. You can just read it, that's fine.
I want to make sure. Go ahead. You read it. Top paragraph highlighted.
I think you need to read the entire article, and in fact, I would encourage you to.
I've read the entire article, but that's your line you wrote. It makes it, if you believe that police are racist, abusive, and corrupt, then it makes sense to mandate body cameras. That's your sentence you wrote. Correct?
I wrote that.
Okay. You also wrote that if you believe that the police profession is illegitimate and untrustworthy, then it makes sense to construct and empower layers of civilian oversight. So you don't like civilian oversight of police, do you?
No, I do like, well, civilian oversight, yeah, I do like civilian oversight and political oversight of the police. Would you like me to read the entire article? It'd be great.
No, not really.
I
'Cause
suspect not.
we just need that one sentence. I mean, I don't know how you can put it in a better context, but no.
Have me read it and it'll be a better
Sure.
context.
Well, you're okay with civilian oversight of police? you said.
Yes, I think civilian oversight, one of the things we learned about civilian oversight, there was a risk, or there was a belief that when you bring civilians in to evaluate police, the first thing you have to do is get them to see the world through the lens of the police officer. And so that required training. It required them to actually go through what police officers go through the simulators, and to understand the law. And then we put them in a sim to understand the reality of it so they could feel it. Then they could actually engage in honest accountability. Civilian oversight, people got nervous because they thought civilians were going to be harder on the police. What had ended up happening is civilian oversight actually was a lot more liberal with police performance than their actual police officers were. And so any concerns about civilian oversight really came down to, are the civilians who are conducting oversight doing it through the lens of a reasonable officer, or are they coming in to conduct civilian oversight and actually intentionally not allowing the officer's view? Civilian oversight in the progressive reform area, there were some examples of it where they would say, if you want to belong to the civilian oversight board, you cannot have been a former police officer, you cannot be related to a police officer, and you cannot have gone through specialized training for police officers. And so when we started to see that, we would push back on that kind of reform effort, because it was actually having people, civilians, evaluate police without actually doing it through the lens of the officer, which is what the law required. So these are debates that are happening across the country. So to ask, do I like them? My answer would have to be, well, which one?
Well, you made sure that when you have a son that's a police officer, correct?
Well, to me,
Your Honor, relevance?
It goes right to his statement about, I got a quote regarding civilian police.
His
You
son?
can do the quote, but ask him about his son, I don't think.
That's
Well,
not
it
relevant.
pertains to his son. You select,
I'll sustain that objection.
your comment, you selected a department where politics hadn't infected the agency or civilian leaders for him. Isn't that true?
I think she sustained the objection.
Well, I read the quote. She said,
Appreciate that. Different questions.
well, it's a different question. The quote is, you made sure that politics hadn't infected the agency or civilian leaders where your son became a police officer, right?
Objection, Your Honor. This is the same topic, so.
What?
It's the same topic, but.
About his son,
that
how is
wasn't
his
the
son
question.
relevant?
So, you asked a question, she objected, I sustained the objection, you asked another question.
Rephrased it.
About his
And
son.
then he said, oh, you sustained, but he didn't mention son the second time. Then the third question, now here's the son again, so.
Well, this goes
You
to,
can ask the second question again, and then you can bootstrap that to make it relevant,
Well,
but
it-
whether or not his son is a police officer, I think is beyond.
correct. But
Because here is an
the thing is where he goes, why he chose where his son went. And that's what his quote was, that civilian review boards where civilians hadn't been infected.
Right, so the second way that you phrased the question was fine.
Okay. So you made sure that politics hadn't infected the agency or civilian leaders, correct?
Yes.
You have a problem with prosecutors who try and hold police officers accountable, don't you?
No.
No. Do you remember talking in once again, Betsy Brainer Smith? I think that's how you say her name, nationalpolice.org, NPA?
Yes.
Do you remember telling her you have a problem with prosecutors who charge police officers where you lost the gatekeepers? Progressive reform activists trying to hold officers accountable are doing it unjustly if they don't know what they're doing, or corruptly if they do. That was your quote. Do you remember that?
That's absolutely true, yes.
Okay. So that's so I'm a progressive reform activist prosecutor.
You asked me if you are? I don't
Yeah.
know you, sir.
It's your mission right now to be here, right? You're the tip of the spear. You said that before, haven't you?
When I talk about tip, I'm talking about a consulting division, because what we do is we're going around and we're training a lot of investigators and evaluators on the types of issues to look for, the human performance issues that impact perception and cognition. And then what we do in the consultant division is we actually take all of that to real world cases. So when I talk about the tip of the spear, I'm talking about if our arguments aren't persuasive in court and they're not persuasive in agencies, then we have to do a feedback and go back to the trainers and say, look, these arguments aren't working, these things are not, we're not being persuasive in these areas.
Okay. Do you remember Eric Hine Academy? A guy from, I think he's from Holland. You talked on a podcast with him?
Yes.
Okay. Do you recall saying, my personal mission right now is to ensure those officers who are having juries, legislatures, their own chiefs, administrators, and prosecutors indict them in a court of public opinion and criminal cases without any knowledge of human performance. I want to be there with them. My job is to be there in that courtroom. That's what you said.
Right, so what we're saying, like we talked about earlier, like honest accountability versus corrupt or unjust accountability. The two standards are, if a prosecutor is trying to hold an officer accountable to a standard that is vague, uncertain, and the officer's never heard about, then that would be a standard by which an officer could not predict the lawfulness of their own performance. That would be unjust or corrupt accountability. If a prosecutor is attempting to hold an officer accountable to a standard that is beyond human performance capability, that no human could do, then that is also another example of what I said is, if they do it unknowingly just because they don't have an understanding of human performance, then that's unjust. If they do it intentionally, then that's corrupt. My job and our job is to ensure that the triers of fact understand the reality of human performance in critical incidents so that we have honest accountability, not unjust or corrupt accountability. So we are 100% committed to honest accountability of police officers, and that is part of our mission statement.
Going to your actual report, one of the things you talk about, you kind of very similar to Professor Stoughton. You talk about when you look at a use of force event, there's got to be intent, means, ability, and opportunity. That's how you phrase it.
Correct.
All right. And intent means somebody wants to do it, right?
They're willing to, yeah.
Willing to. Means they have a weapon system,
Right.
as I think you said it. Ability means physically upright and mobile. And opportunity is a position where the weapon system could actually reach you. That's
Right.
how you phrased it in one of your podcasts. You don't like, in terms of determining that, you don't like the American Law Institute, new standards where they talk about necessary. Officers struggle to understand necessary, proportional, and minimum force standards, right?
Right.
Okay. But one of the things you did in this case is you said Patrick had intent because he had disproportionate resistance, right? That was your statement, right? Disproportionate resistance. Patrick engaged in disproportionate resistance, ergo, the officer could assume he was going to use the taser on him.
Yeah, so when an officer's evaluating a suspect's conduct, remember it's based on training, education, experience, and reasonable inferences. I think the statement that he's making is when the officer sees somebody who is resisting at a level that is disproportionate to the suspected offense, that it is reasonable for that officer to believe that there's much more going on, and they have to prepare themselves for the fact that there might be warrants, there might be weapons, there might be undiscovered crimes. And so is it reasonable for an officer to believe when someone is fighting you, you think you pull them over for a turn signal violation, and they're fighting you at this level of aggressiveness, for example, that it's reasonable for an officer to infer there's something more serious going on that this guy's aware of that they've yet to figure out?
But that's what I'm saying. But for the officer, you don't like proportional use of force. So you can use it against the victim, Patrick, because he's disproportionately resisting, but an officer, proportional level of force, they don't know how to use that. That's crazy. How do you expect them to do that? That's your position, right?
No.
No. Well, I said officers struggle to understand necessary, proportional, and minimum force standards.
Right, so these are not standards that are typically involved in constitutional policing. These are not standards that officers are trained against when you talk about. In fact, Stoughton and his academic colleagues have written articles to try to incorporate these standards because the current standard doesn't. So they're advocating that necessity and proportionality and minimum force necessary. So if you imagine for a second, again, it is beyond human performance capabilities for a human to look at another human and know what's the minimum force necessary to arrest this person and overcome resistance that they've never felt. And yet we'll see that language sort of incorporated because it sounds great, right? But we wouldn't ask a firefighter to put out a fire with minimum water necessary. We don't ask wrestlers to pin somebody with minimum force or football players to tackle with minimum force because a human cannot possibly know what that is in advance. So this was the argument I was making and trying to point out that these vague standards that have not evolved through case law, officers don't know what they mean. And so we have these conversations. These are the academic debates we spend an awful lot of time. So, welcome to the debate. These are things that are not well settled. These are things that academics want to have to wrestle with, and they're wrestling with them in courts as we speak.
And so you don't like them. That was my point. You don't like minimum standards. You don't like proportional use of force, right? You don't like putting that standard on an officer.
I don't like any vague standard that doesn't allow an officer to predict the lawfulness of their own behavior. So if you tell an officer you can only use minimum force, and they would call me when these new standards for, again, a lot of the progressive reform efforts were coming after, they were coming fast. And so agencies would call and say, hey, we got this new policy, officers have to use minimum force or use only force that's proportional. What does that mean? And we would say, that's not been decided yet. We don't know. And so until those things are fleshed out, either defined in terms, this is what we discussed in Bakersfield with the ACLU, they were using terms that police officers had never heard before. And so, and I got them to agree that we cannot have standards that don't allow officers to predict the lawfulness of their own behavior. They're like, of course not. That's a due process violation. It's absence of notice sort of thing. If the officer doesn't know what's illegal, we can't hold them accountable for violating it. And so my objection was when we start adding all these new terms, and I've got a slide with like 15 different terms I've seen, officers don't know what to do with them. So that's what I was pushing back against. But in my academic capacity, those are just discussions we're having until those things get fleshed out more, either in courts or through legislation.
But it's okay for an officer to determine disproportionate resistance from a person.
Absolutely, yes.
One of the other things you said, the basis for why this was justified is that you even talked about it to the jury, MMA, right? You said, in real-world combat sports and law enforcement experience confirms that suspects can turn explosively from the prone position. In wrestling and mixed martial arts, MA, fighters routinely explode from a prone position to reverse control over their opponent.
Yes.
Okay. So you're comparing Patrick to an MMA fighter. You get to react like that.
I've seen that in jiu-jitsu, not just MMA, with brand new kids who've never been trained before or adults who've never been trained. It's a human I'm comparing to another human.
So even though MMA fighters go through 3 hours of training every day, 2 hours a day, or 6 hours a day, that's a very different thing than Patrick, who's an African immigrant with his pants falling down and barefoot out on a grassy front yard, right?
Yeah, completely unrelated, yes.
One of the other things you talked about was his superhuman resistance. That was your words in the report, right?
Yes, I think I used the word superhuman as what it was perceived to feel like, because all of the efforts that the officer was putting into it was unable to overcome the resistance. So what that's often is like, it feels like it's superhuman resistance. Superhuman, it's not a legal term of art. It's a lot of resistance.
So you're taking that inferences from his statement, that suspect's superhuman resistance.
Yeah, it's a characterization of the level of resistance an officer in that position might have characterized it as.
So what Patrick did was beyond human, having a higher nature, greater powers than humans have. That's what you saw in the video?
If you're going to read that word literally, I suppose that's what the dictionary would say. That was not how I intended it,
You're
certainly.
a lawyer, right?
I am.
Lawyers use words, right?
We do.
And so words have meaning, right?
They do.
So you put it in a report that a guy who stood up and walked across a yard was superhuman, right?
Well, the characterization of that force would feel like that.
He didn't have superhuman speed, though, did he? Because clearly he got caught.
He did not have superhuman speed.
But just superhuman strength to be able to stand up, right?
The literal definition of superhuman, I suppose if I go back and rewrite it based on this cross, I would use a different word just to avoid this, but the concept's the same, which is when you're trying everything you can to overcome the resistance, and this guy's standing up, you're an adult male, and another adult is standing up with you repeatedly, and there's nothing you can do to stop it. I use the concept of, it would feel like, almost like superhuman strength in that moment. Like, this is not consistent with my understanding of past practices on trying to control a human. But yes, the word superhuman was probably not the best choice of words.
Your Honor, I got maybe a few more, I don't know if you want to stop now, I think I could wrap up here relatively within the next 5. Well, I can stop there, I don't want to get into a minute, so I can wait till Monday.